Good afternoon. My name is Josh Wild, the Editor-in-Chief of IAM, and it is my pleasure to welcome you to the very first IAM Market webinar, which is on preparing patent packages for sale. We have over 350 people signed up to hear and watch today's presentation, to be given by Kent Richardson of the Richardson Oliver Law Group, which is based in Los Altos, Silicon Valley. I am talking from IAM's HQ in London, and I'm delighted to say that audience members are located across the world, in North America, Europe and Asia, even in Australia and in New Zealand, where it must be very late. We thank you all for joining us. Before I hand over to Kent, I would just like to run through some housekeeping points with you. If you are on the phone for event audio, we are muting all attendees for the complete duration of the webinar. There will be time at the end of the webinar for Q&A, so if you wish to ask a question, please use the chat functionality and send it to staff, and I will be asking the questions that we get at the end of Kent's presentation. During the course of Kent's presentation, we will also be running 4 polls. The results will be shared at the end of the presentation, and as I know there are a lot of lawyers listening in, I should say that all responses will be in aggregated form only, so no one will be identified with any particular response. So I would encourage as many of you as possible to take part in the polls. Finally, the webinar is going to be recorded, and the recording will be made available to all attendees at the webinar in the course of the next week. And with that, I'm delighted to hand you over to Kent Richardson, one of Silicon Valley's top IP deal makers, and someone I first met when he was heading up the licensing operation of Rambus more years ago than I care to remember. I'll be back at the end of Kent's presentation to run through the poll results and to moderate the Q&A. And with that, Kent, over to you.
Thanks a lot, Josh. Thanks again for attending, everybody, and let's talk a little bit about what the topics we're going to discuss are. So we're going to do a quick overview of patent sales. For a lot of you, I took a look at some of the people who had signed up. I thank you very much for signing up. This will be a little bit old hat for you. We'll talk about value driver patents in sales packages and why they matter. We'll look at contents and some best practices around patent packages and presenting packages for sale. And then we'll talk a little bit about a diligence checklist as a seller, what you need to think about and should be considering before you go and sell. All right, so what is a patent package? That is all the material that a buyer needs to evaluate whether a group of patents might be worth buying. It's not whether the person's going to buy the package entirely or all the patents. It is whether that person might be interested in buying those patents. And we'll talk about why this matters later on. Importantly, the package signals the patents are available for sale, that there is a willing seller, and that there is a process to which the seller has committed. So think about this. If you go up to any other company who has patents and you wanted to buy some of their patents, you wouldn't know if they're available for sale. You wouldn't know if the seller is willing to sell at all, and you wouldn't know if there was any process by which they were committed to. So that's what a package is really about. And typically what that package is a written material describing the patents, the relevant market, and provides some contact information for the seller. And I think this last point is pretty interesting. I've seen a number of packages where the patents and the relevant markets were presented, and then insufficient information was presented to contact the seller. So you'd be surprised at some of the information that might be forgotten on occasion when you're trying to get all the meaty material together. Where do patent sales fit in the overall monetization options? And I'm not going to go into great detail on this, but the reality of it is there's a number of different ways to try to make money off your patents. And when you look at sales, it is one of the simpler ways to make money. Basically, what you're doing is you have a private, semi-private, or quasi-public sale. It's very fast. You're going to just sell the patent for many companies, many companies, it is your best monetization option, and it is the least costly for you. It also is the one that's going to make you the least amount of money. You can go third-party licensing, have another company go license your patents. You can license your patents directly. Usually you make the most amount of money. It has the highest risk. Sales, again, for the vast majority of companies, that's the way to go. That's why we're talking about sales today. So what is a brokered patent package, for example, or what's in a package that's going to hit the market? So this one actually is one presented by a broker. What does it have? A list of patents for sale, literally the list of patents. The patent numbers, all of them. Usually you have additional information like priority dates and titles. What applicable market? Does this apply to LEDs, auto drive vehicles? Infringement analysis, claim charts, or evidence of use. And then some background on the seller. Who's selling? Why might you be selling? What kind of process are you proposing to sell these patents? Additional information that you'd be able to get, asking prices, sometimes in the packages, often provided separately, the bidding process and the due dates, and then any kind of special circumstances like whether the licenses are required, specific encumbrances may or may not be in a package. The specific example we have here is one from Patent Profit, broker named Will Plett. It's a single family, had 15 patents. Property date was 2006. We received it in July 2013. It sold in October 2014. The asking price was 7 figures. That's pretty typical. We don't get an exact price, although that's changed over the years. We get exact prices more often. And then multiple claim charts or evidence of use were presented. And then there was a company that actually bought it, Fingerprint Cards AB. It's a company that you can imagine might have been concerned about Apple, and they bought these patents for defense against somebody like Apple. You can imagine that might have happened. So why care about the package the package itself? Why does this matter? So selling patents is tough. The market is opaque. Who's buying? What type of patents are hot? In other words, what patents are selling and which ones aren't? What the price should be, and what are best practices? Pretty obscure. There's a group of brokers who are really quite effective at this. There's a number of sellers, but general knowledge isn't broadly disseminated. Also, 70% of the patent packages are not going to sell. So if you think about this from a real estate point of view, if you had 7 houses listed for sale, only 3 of them would ever sell. The others would go empty. There are factors in the sales package that can help you improve your chances of selling. And then we're going to talk about some of those. The other thing to keep in mind and why the package matters, if you are a buyer, you will look at about 1,000 packages per year. That is 5 packages per working day. I've spoken to a lot of buyers. We do a lot of buying for companies. And so all of us have to be very efficient. One of the bigger buyers that I've talked to, his take on this was, if I don't like this package, there will be another one tomorrow. So you should assume that buyers have little time to think about any kind of subtlety in your package. Your value drivers have to be clear and upfront. And how do you make, ultimately, the patents you're presenting stand out in a good way? So, ultimately, Michael Pierantozzi over at HPE had this great line, when he was talking about selling patents. He said, when I'm selling my car on Craigslist, I don't list it as car. And I thought that was a great comment on how to sell patents. You don't list just the patent number. You have to put some of the story behind it and explain what the value is behind the patents you're trying to sell. And we'll talk more about that. How big is this market? Well, it's pretty big, and it gets bigger. We started to track the asking prices of all the patents on the market. And we're tracking now about $11 billion in private and public or quasi-public deals. That's over 3,600 package, around 87,000 assets, and 108 technologies. So if you want to buy something as a buyer, you can absolutely find something that you are interested in buying. The 2016 market, we do an annual report on this, and we're just pulled all our data, continues to be robust. Interestingly, looks like prices have stabilized, at least asking prices have stabilized. We'll have to see about sales rates. And we think that overall, you can see that the more and more packages are being presented to the market. Just one note of caution, sales rates for 2016 Q1, Q2, Q3 are only actuals, and it takes about 18 months for us to see those sales. So because there was a big uptick at the beginning of, or at the end of last year and beginning of this year, you won't see the sales from those yet. It'll take a while for those to come through. So the sales rates here, or the sold packages, are underrepresented. Who's involved in the patent market ecosystem? Who are the people that make this market happen? There are the buyers, the Apples and Amazons, the people you'd expect, the NPEs like Intellectual Ventures and Acacia, and then there are also the defensive aggregators. There are sellers, lots of SMEs, small, medium enterprises, usually ones that aren't doing as well or no longer in that business, so they pivoted to something else. Some big companies, some notable big companies, Cisco, Yahoo, AT&T. And then also some of the NPEs sell, Intellectual Ventures sells, as do some of the defensive aggregators. For example, AST only buys, turns around and sells the patents. They license the people who participated in the purchase. And then also the last part of this transaction market are the deal makers and the brokers. So people like us, we advise companies on selling and buying. There are all kinds of brokers, and if you're interested in a list of brokers, we keep a list of brokers on our website, just publicly available for you to go and get. There's also bankers, law firms, and a number of other people who facilitate the transaction. So that's kind of what the ecosystem looks like. When we think about the patent package, what we're trying to do is get the sellers to be able to present to the buyers in the most compelling way possible. And we propose the following process for thinking about how to ready your package, right? So first thing you have to do is figure out how you're going to group your packages, and you're going to look for value drivers and supporting patents. Those value drivers patents are really the anchors to any patent package. Usually you have some evidence of use for those value drivers, or you have some compelling story of why those particular inventions, those specific patents, are the ones that are going to drive exponential value into the package. Now you kind of have to make a decision about whether you're going to sell directly or not, whether you're going to use a broker. You're going to build the value proposition. So you've got these value drivers. Now you've got to build a story and the overall package with all the components, completing that package, and then bringing that package to market. Last step is, monitoring the bidding and buying. Interestingly, a lot of people worry about that monitoring the bidding and buying and ultimately closing. I'd say the first 5 steps are more difficult than the last step. Once you're in the bidding and negotiations and closing, it's much easier. All right, so let's talk about those value driver patents. So these value drivers are claim charted, high volume, high revenue products and services in the overall market. You can include assumptions in your claim charts. We recommend that you just articulate that this is an assumption. We're assuming that these products work this way. So we're mapping all these claim elements except this one, we assume it works this way. We often refer to these claim charts as actually evidence of use or indications of use. So I'm a patent attorney. A claim chart actually for litigation purposes is very detailed. What we see in patent packages is not that level of detail, and so we prefer to refer to them as evidence of use or indications of use. The indications of use are where we've made quite a number of assumptions, and we don't know for sure if the products that work that way. The evidence of use is we are quite sure the products work that way, but we haven't done a full litigation claim chart. So why are value drivers identified? It ultimately, we're trying to relate to why buyers buy. Buyers buy because they can point at one patent and understand, or a small group of patents, and understand how they would use those patents, typically if they're corporate buyers, to defend themselves. They know that those patents will be the ones that they rely on when they look into their portfolios to defend themselves against specific other corporations. Next, you tend to bundle other patents around your value drivers, usually in the same technology area. It helps focus the marketing materials. Instead of all LED lighting, it's specific kinds of white color LED lights that we're focused on, as an example. And ultimately, the value drivers help dictate the price of the package and improve your chance of sales. So the more value drivers, the more information around those value drivers, the more likely you are to sell. So why do we care about the evidence of use? It's interesting. I've had buyers say, well, I never even look at the evidence of use that the brokers or the sellers provide. I'm going to skip their package and look directly at the patents. I've been told that many times. Turns out our data says differently. Our data says actually that's probably not what's going on. You have a 41% more likely chance to sell your patents if you have an evidence of use, and you are 23% less likely to sell without an evidence of use relative to the overall average sales rates. Asking price premiums of 34%. These are really important numbers. Those are big numbers and really impact your ability to close a patent sale and also to price your patents. So what's really going on here? The buyers do not accept at face value the evidence of use. They will rebuild the evidence of use, but the existence of the evidence of use matters. Why? It signals which patent and which specific claim matters, which elements of those claim matters, which specific products could a buyer use these patents with, and it takes an abstract discussion of how some general group of patents are applicable to a general market to, from that generality to, here is a specific claim in a patent that is issued that applies to this product. And because you get that level of specificity, it helps everyone focus. So what technologies and products and services have people focused on? So we took all the evidence of use over 5 years. We took summaries of those, and we said, let's look for companies, technologies, and products that are occurring the most in those summaries. And that's that word cloud you see on the left-hand side of the screen. That word cloud is shows you which companies are targeted most often by the evidence of use. Not surprisingly, over the last 5 years, Apple, Google, Microsoft, Samsung. You see some other interesting technologies in there, 3GPP, LTE, and then you also see specific products like iPhone is in there, iOS, and Bing. So we thought it was pretty interesting to go through this, and we'll be doing it every year to look at what people are targeting. But it's also interesting to think about what does that mean from how you can position your own patents for sale. Clearly positioning your patents such that their evidence of use are targeted at small markets like less than $100 million isn't a good idea. Targeting larger markets are more valuable The companies who are most likely to be in a fight today with another company are the companies who are most likely to be buyers. Hot technologies, interesting, that continues to change. Mobile phones were much hotter a few years ago. They're still relatively hot. Social was very hot a few years ago. It's not as hot as it used to be. Wearables got a lot hotter in the last year. All right, so now let's move on to, we talked about value driver patents. We looked at the process for selling patents. Now we'll look at the contents and best practices of a patent package. So what's a minimum viable package? What is being offered? That's the first thing you need. How many patents, how many patent families, and that it's for sale, not for license. One good practice tip here is to be very clear that you are offering for sale and not for sale or license. And one of the reasons here is if you're offering for license, that can end up in the litigation group or another department from the people who evaluate patents for purchase. How big is the applicable market, and what is its specific technology? And then what is the exact patent list? We recommend one Excel spreadsheet, one asset per row in that Excel spreadsheet, and is the complete list including the full patent families. What the status of the patents are, whether they're expired, pending, or issued, and if they are related by family, priority dates, those are good practice items. Surprisingly, many people just do not provide the list this way. If you can imagine, many buyers use automated tools for extracting information about potential patent packages. Remember what I said earlier, that a buyer will look at 1,000 packages in a year. Anything that slows them down makes your package move lower in their priority list. So providing a clean Excel spreadsheet, for example, really helps them evaluate packages faster and therefore moves you up the list. Who should the person contact if they're interested in getting more information about the package? What's the sales process? When is the bid due date? And what's the explanation of the process? Will you accept all the bids on one date? Will you accept initial bids by one date? And then any disclaimers. And the disclaimers are something that can be quite important for many purchasers. The purchaser wants to know that if they're evaluating the patents for purchase, that they're not going to be accused of willful infringement simply because they decided to look at the patents for purchase. That was the minimum viable package. Now let's talk about the best practices package. Is there evidence of use available or actually provided? Some brokers provide the evidence use right in the sales package. Others provide it as a separate agreement, and it really depends on the situation. Pricing information. Are you going to provide a specific target price, or are you going to give a range? History of the seller, inventor's commercialization, always helpful to provide some backstory on your the inventions. And then additional marketing and what problem was present in the market? How does the invention generally address the problem? Companies identified as potentially infringing, and then any technical references also can be helpful. I think that we're now at the point where we're looking at best practices. Are you burying the buyer with too much information? Are you providing the right level of information? I have to say that's on a case-by-case basis, and it's just something to be aware of, is providing 50 pages of technical information isn't going to be that helpful. Can be included citation and ranking analysis. I don't know a lot of buyers who pay attention to that. I think unless it's extraordinary, most people do not pay that much attention to it. What else do you need? You don't have to provide this in the package, but you need to be able to have this ready. Patents and file wrappers. OCR copies of the patents and file wrappers so that they're text searchable. Any prosecution of any international patents and any unissued applications. If you're including all those should be, should at least consider including those. A lot of people use a Dropbox or some cloud-based storage for that material for anybody interested in potentially buying. Again, I mentioned pricing, whether you're going to give a range. A lot of people say mid 7 figures, high 6 figures, that kind of thing. And we're seeing more people move to, we want $750,000, $950,000, $2.1 million, being more precise. You're also going to have to provide information about encumbrances. Are there existing licenses? You may have to have that disclosure covered by an NDA. You may have to think about whether you're going to use a whitelist or a blacklist. Blacklists are, none of these companies can be licensed. A whitelist is the buyer says, I want, sorry, let me be clear about this. A whitelist is provided by the buyer saying, I need to license these set of companies. Can you tell me whether they are available for license? A blacklist is, if you cannot license these companies, we're out. All right. I said that a little bit wrong. It's blacklist is none of these companies can be licensed. Otherwise, we're out. Sorry. I think the last item that's very interesting here is the assignment records. Like I said earlier, I'm a patent prosecutor, and the assignments were something that were handled late in the game. As we look at the assignment record after doing a lot of buying and selling, we're amazed at how inconsistently handled they are, and it causes quite a few problems. So we recommend checking your assignments early in your process, simply so that you don't have to go run around at the end and try to get inventors to sign assignments that they should have signed years ago. All right, so let's go into the diligence checklist. First things first, pre-sales diligence, things that are absolutely necessary. Take a look at a typical purchase agreement for patents. Can you sign up to the representations and warranties in that typical agreement? You should check that very first. One of those representations is that the encumbrance list, as stated, the people who are already licensed or the unlicensed people that you're providing in the schedule of exception, or rather the schedules at the back of the purchase agreement, are specifically companies that you can represent and warrant are either licensed or unlicensed. Chain of title, we just talked about that, complete assignments. Chain of title, make sure that if there were any intermediary owners, that everybody signed everything they were supposed to, complete assignments from the original inventors. Also, were the inventors employees at the time, or were they contractors? Do you have those agreements? Was there any government funding? Were you involved in any standards bodies that might affect those patents? And then, did you comply with small entity status requirements, if there were any at the time? Those are kind of the minimum set of pre-sales diligence that you should at least consider when you're putting a package together. All right, so, the interesting thing about patent selling is it really is a multidisciplinary set. It's not just being a lawyer. It's not just being a marketing person, not just having the capability to understand the technology, but it's a combination of all those things, and then also this ability to sell. So the patent package helps frame the discussion with a potential buyer who's going to be looking at the technology, the market, what your sales process is going to be like, and then any of the legal elements. And the patent package is sort of that point of focus for all of those elements to come together. Make sure you do your checklist up front. You may only get one bite at the apple. Remember, if you're looking at 1,000 packages, the buyer makes the decision. I mean, we tend to make our decisions in under 2 minutes, whether the package will make it to the next round. So how do we do that? A lot of times it's just the wrong technology. We don't have any buyers in this area right now. We're not interested in that package. And that's a fairly easy test for us. You notice what we didn't do is we didn't do any legal diligence. One of the things that we always ask our buyers is, when evaluating a package, if you assume everything was perfect, the claims were perfect, the market was perfect, would you still buy this patent? And the answer is often no. And the simple reason is because the patents, even if they are perfect, aren't useful to us in what we need them for. Helping people evaluate whether the patents you're looking at trying to sell is helpful for them to solve their problems is probably the most important thing you can do in the patent package. Helps them and it helps you. Keep in mind, you're going to probably bring your package out to at least the dozens and maybe hundreds of potential buyers. You wasting time trying to sell to somebody who will never want to buy your package is also inefficient and not particularly effective. This is, putting the package together is really, part of the overall process. And it's interesting, the longer I've been in this business, the more I appreciate the skills associated with being a good salesperson. Some of the best brokers I find are really good salespeople. They listen to the needs of the buyers. They listen to what the sellers want to get out of selling their patents, and they really put those two together. And they also have an ability to run a sales operation, checking up with people, contacting the right people, continuing to basically chase people to help close those deals. So this putting a package out there is kind of like inventing or building a great product. It's an important part of an overall successful business, but now you need to be able to go out there and sell it. And the patent package is, you have the engineering or the patents themselves, you have the marketing materials, which is the package, and now you have the sales team, and you need that sales team to go out and sell that package to people. So it's a part of an overall process. All right, so Joff, I think I got in a little bit early and under the wire, but I think we might have poll results at this point as well.
Yeah, I think on the polls, Ken, we decided not to run them in the end. Okay. Just because there's so many questions coming in that we thought it would be more profitable to go through those than look at the polls. I have to say to everyone, we were kind of thinking it's going to be like a conference where people didn't ask questions, but it turns out that there are a lot of questions. So I'm going to run through those. If we don't get to your question, apologies in advance, but what I would say is that we will follow up with anyone whose question doesn't get answered, and we will provide you with the answer sometime over the next week. So with that, Ken, here we go. First question, when selling a patent, is it typical to include the right to license it back from the buyer for the seller's own use?
Yes. That's really common. And actually, the real question starts to get into things like, if I have the license back, what happens if my company gets bought? What happens to that license? So now you start to have conversations about how many times can that license transfer through an assignment. But yes, very common.
Are there circumstances where you wouldn't do it?
I have not seen one where the buyer is unwilling to do that. And if you think about it, go ahead.
I was just thinking maybe one circumstance might be where a company is getting out of an area and actually isn't going to have need to work the patent anymore.
Yeah, and that's more on the seller side. So if you're the buyer, if the company is getting out of that business, it doesn't really matter that much. You have to scope the license appropriately. Usually it has something along the lines with, here's the scope of the kind of technology that you're being licensed back on. And if you don't have anything in that area, it's not really that risky from the buyer's perspective. Now, our buyers are corporations, and so they have specific use cases that they have in mind. The vast majority of time, it doesn't involve using the patents against the seller in any way. So the other thing is most sellers, would you get fired if you didn't get the license back at some future date?
Yeah. I imagine that concentrates the mind.
Yeah.
Okay. Second question: Is an issued patent more valuable if accompanied by an active continuation?
Yes. Oh boy, yes. Yeah, definitely.
Can you talk us through that?
Yeah, so absolutely open continuations help a lot. In fact, where we've sold patents, we provide not only the issued patent and the open continuation, but we will provide an outline of different kinds of claims that a buyer might be able to get.
Okay. And in terms of values, can you give a kind of, you know, with and without in terms of difference in value?
No. I think the more interesting question along that lines, although that was a tough one. I don't think I have the analysis on it for this year, but I can say the following: that there's likely a price difference. There's definitely a difference in the chances that the package sells.
Right.
So when you think about value, there's two components. There's the price that you might get, and then there's the chance that it sells. And keep in mind, if only 30% ever sell, and a continuation improves your chances by even 10%, that's significant.
Yeah, makes sense. Okay, next question. I'm not sure, I think you might have touched on this in the presentation, but let's just clarify it. Is there a minimum number of patents that I need to have, or should I consider selling even just one patent?
So yeah, you can sell one patent. They're a lot harder to sell. The good news is there's things like IP3 now where it's much easier to sell a single patent. But the hard part about selling a single patent is buyers aren't unlikely to put a large value on that single patent. It's just their comfort level, and there's some practicality to this. So imagine you had a single patent and it was a value driver and you wanted $600,000, and frankly it might very well be worth $600,000. If you're the buyer and you have to write a check for $600,000 and you go and talk to finance, and finance says, hey, your average purchase price for patents is only $50,000, why are we paying more than 10 times that? You kind of have a problem internally in your organization. Rationally, you should pay the $600,000. Unfortunately, you can't get buy-in from the other groups to say this one's worth it. So it doesn't mean you can't do it. It's just more complicated. It takes more time, and it reduces your probability of sale. But like I said, there's other avenues now, like IP3, where
so I was just going to clarify to people that people that hadn't heard of IP3, and I'm sure most of you have, but IP3 is the Industry Patent Purchase Promotion, which was a scheme put together by a group of companies in various industries earlier this year. I think companies included, and Kent will know better than me, it was Google, Microsoft, Ford, and maybe 20 others. And this was a scheme run by Allied Security Trust where people were invited to send in patent packages and individual packages, individual patents with a specific price, and AST would make a yes or no decision pretty instantaneously. Is that right, Ken?
Yeah, it's run quite quickly, and deals that normally take sort of 6 to 18 months get done in less than 3 months.
Okay. And do we have any news on how that went? Is there anything that can be shared publicly at this stage about that, or are we still awaiting?
We can't say it was successful. In fact, my partner Eric Oliver is here, and he was there at it. It was definitely successful. I think AST will be publishing more information about that.
Okay, thank you. Next question. Regarding the claim that patents with evidence of use are more likely to sell, someone's saying here that might not be true. Brokers tend to only spend on evidence of use for assets they believe valuable. So it may be that assets believed to be more valuable by brokers are more likely to sell, not necessarily assets with evidence of use are more likely to sell. Does that make sense to you, Ken?
Well, the question might devolve down to correlation and causation, right? So we correlated that evidence of use improves your chances. Do we know for sure that that's what caused it? We know where we buy, that's what's causing it, but we don't know that across the market. So I think that the point's probably valid, but that's what correlates.
Yeah. So I guess that the lesson is, if you think you've got valuable patents, then you really should be providing evidence of use for that.
If you can, yes. Or indications of use. In other words, here's specific products that we think have all the elements.
Okay. Yeah, makes sense. You spoke about blacklists and whitelists.
Yeah.
Someone asks, how often are blacklists and whitelists used?
So depends on the seller. So for small companies, almost never as the seller, because usually you have no encumbrances and it's very easy. For big companies, especially really big companies, it's much more common because, frankly, they can't rep that they know every company that is licensed, but they can usually rep that specific companies are not licensed.
Okay. Another question. Up until now, this has been a very US-dominated marketplace, the whole buying and selling of patents. How is that still the case? Is it still a US-dominated market? Among buyers and sellers, how many are not based in the US and not from the US? How many are European?
So our data says that it's still dominated by the US market, but not as much as it used to be. And unfortunately, I don't have the up-to-date buyers list from our analysis from this year in front of me, but it is dominated by US buyers, but it's definitely changing and shifting. And a really good example of that shift is the number of NPEs buying. It's gone down quite a bit.
Okay.
So although that doesn't quite answer the question on European or not, most of the NPEs are US based.
Yeah, absolutely. But I mean, anecdotally, what we're hearing, for example, is that now people seem to be much more interested in, say, German portfolios than was the case in the past.
Yeah, absolutely. We have buyers who 3 years ago, European or Chinese patents were nice to have. Now they are necessary.
Okay, Chinese patents as well?
Yeah.
That's interesting. Okay. So here's another question. This kind of reflects maybe the zeitgeist of the marketplace at the moment. How much are we talking here about patents alone, and how much are we talking about patents plus? So combining patents with, say, know-how and trade secrets as complementary assets in a package? We do not see, so that's a great question, and it's a little bit complicated. So let me answer the question as best I can. Typically, a patent buyer, is not in the same department as somebody who buys technology. All right, so a patent buyer is buying because they have a specific use case for the patent. They are going to defend themselves or counter-assert against somebody. They're going to go try to make money. They're going to go bolster their patent portfolio. If you're looking at licensing in technology or know-how to enable you to build new products, that is in a different department, usually in corporate development, where they are trying to find a way to deliver a new product or service to the market, and they need some additional technology. So for what we see in high tech, that technology is not found in the patents themselves. That technology is found in software, engineers' heads. And so the corporate development is much more interested in finding the software of those engineers than they are in finding the patents. Yeah, that makes sense.
That's not true for all industries, and I have a very high-tech focus in our practice, so you have to be careful on that. And my wife's in biotech, and that's very different.
Okay. I guess there's the inevitable question, the impact of Alice and Mayo and other Supreme Court and CAFC decisions on patent values. Has that created downward pressure on values? Has Alice brought down the value of software patents?
Yeah, so when we did the analysis last year, Alice appeared to have crushed the market for fintech patents, crushed it. Where fintech patents were selling well above the market rate, they were selling well below the market rate. For software, we saw some impact on the sales rates, and I look at sales rates first as opposed to asking prices here, because sales rates were people really putting money down to purchase patents.
Yeah.
On pricing, surprisingly, fintech did not seem to adjust its price, nor did software that much. This year's data suggests that software sales are down more noticeably. Fintech continues to be crushed, and we should see some bounce back in the pricing and sales rates for those patents. I think we said it last year, it's the buyer's market. It's a great time to be a buyer. It's not just a buyer's market. It's a great time to be a buyer. If you assume the pendulum is going to swing back, it was a great year to be a buyer. And it might very well be swinging back now. It looks like that with a number of court cases. And we should start to see people selling at higher rates in those areas. But we won't know for a while.
Yeah, I mean, I was going to ask you that because we had the Planet Blue decision from the CAFC earlier this week, and we've had a couple of other major software-related decisions from the CAFC this year, all of which seem to have generally favoured software patent owners in terms of eligibility and all the Section 101 issues that were created by Alice. How much of a lag would you generally expect between decisions such as these being handed down and that being reflected in the marketplace?
So, and we don't have data on this, but I'm going to assume the following. If we break the market into three segments, there's going to be the early part of the market, the people who react quickly to this and get out ahead of it and start buying immediately. So there will be a few of those. There will be a big chunk of the market that takes some time to think about this more. And, you know, my guess is that's 12 months before you start to see results. And then there'll be some laggards that can take 2 to 3 years. I think that those early folks are most likely to be NPEs and a few corporations who are, you know, quite quick thinkers and actors around this stuff. But the NPEs tend to be the most active and the highest, or the willing to take the most risks.
Absolutely. So, I mean, is there a case, for example, if you're the owner of a software patent portfolio, is now not the time to be selling? Should you be waiting for, I don't know, 6 months or a year to wait and see how the market develops here?
You know, most people don't have that option, or it's going to take you 12 months, 6 to 18 months to sell your patents anyway. So if you get them into the market now, you probably hit a decent window.
Okay. I mean, one thing you see with house sales, for example, is you put a house on at a certain price and you get into a bidding war and the price goes up. Is that something that you see in patent sales as well? I mean, is it something you could envisage happening?
Yeah, so yes, that doesn't tend to happen as much as it does. Well, so I live in Silicon Valley. It's kind of crazy here. But it doesn't. We don't see it as often in patents. It definitely happens, and some brokers are quite effective at it. I would say the vast majority of the time you have 1, 2 buyers. Sometimes you have 3 bidders, but you don't. I don't know anybody who's ever had 5 bidders, for example.
Okay.
In recent history.
Yeah.
In like 2009, things were a little bit different, but you know now.
Yeah. Brilliant. Okay, listen, I have one more question, Ken, and
sure.
It's a wide open question. Where are we going to be 12 to 18 months from now? How do you see the market developing both in the US and internationally? So
the good news is some of this market has stabilized, right? Prices year over year, first time in a few years that they're basically the same, flat. So that's good news. Sales rates seem to be down and NPEs seem to be moving out of the market, I think that there's a decent chance that NPEs will stabilize. In other words, not decline much further. There might be some lagginess on this. But you should assume that if you thought all the NPEs were going to go away, that's probably not going to happen. So they're still going to keep buying. Sellers, this is the first year where I thought that the market, the existence of the market and the ability to participate in the market isn't the first question anymore. There is now an assumption that the market exists and that it's valid and there's a reasonable way to participate. The questions now become, how do I participate? How does my company participate in this market? What's the effective way to do this? What's best practice around this? And I think over the next 12 to 18 months to 24 months, there will be more and more focus on not what is this market, but much more what are reasonable metrics for things like success in this market. So, you know, we saw a big uptick in the number of packages listed from because IAM Market entered the marketplace and because IP3 entered the marketplace. And so you have this broadening of the kinds of assets and the ways people can participate in this market, and I don't see that that's going to slow down. But I see people thinking harder about how do I make this operationally successful for me. What I mean by that is, how do I make this an ongoing program? How do I get finance to sign off on this? How do I build a financial model around this? What's the best diligence process? Remember, if you have to look at 1,000 packages over the year, that's daunting. 5 a day, and that's not your full-time job. How do I do this efficiently and effectively? So I think the market becomes more accessible for people as they learn how to operate in it more effectively. So does that answer your question?
It does, absolutely. Ken, thank you very much indeed. And with that, everybody, I'd like to thank Kent Richardson of the Richardson Oliver Law Group for a fantastic presentation and for his insights during the Q&A. I'd like to thank everyone who stayed throughout the presentation and contributed questions. I'd like to say to those listening in Australia and New Zealand that you better get ready for work. And for everybody else, enjoy the rest of your day, enjoy your evenings. We'll be sending out recordings and PDFs of the presentation in the coming week. Thank you very much indeed.